Good morning. Today we will discuss nature of intellectual property. Unit 4. In the previous sessions, we have seen research, what is research, what are the research design, research methods, then research problem, how to write the research problem, then how to do the literature review, what are the different tools available to carry out the research, and and in the last chapter we have seen how to write theses or articles for conferences, journal, or how to write the dissertation, and what are the points to be taken care while writing this. In this chapter, we will mainly focus on intellectual property. Again, among that, we will discuss patents, designs, trade, and copyright. So the outcome of this topic is interpret. The student will be able to interpret the concept of intellectual property rights and their role in the technology transfer. Now, there are different kinds of properties. We all know that it can be classified like movable properties, immovable properties, then intellectual properties. In movable properties, we can say car, pen, furniture, dress. These all things are comes under movable property because car is our own property, or bike is our own property. Pen, our bag, laptop, these are all movable properties. Then in immovable property, so mostly land and building, these two comes as immovable property because land cannot be moved and that can be of a person owned by a single person or a group of people. And similarly building or farm. So these are immovable property. Then there is intellectual property. So intellectual property is wherever inventions are there or literature is there, those things we call as intellectual property. So intellectual property is actually a category of property that includes intangible creations. Intangible creations of human intellect means based on the human intellection, whatever they have created, that property comes under intellectual property. So mainly our today's session focus will be on this intellectual property. Now, what are this nature of intellectual property? First is creation of human mind, that is intellection. Intellect. It is created by some person or it is created by some human mind and it is an intangible property. Means it cannot be directly related to any other thing. Then exclusive rights given by status. It is attended with limitations and exceptions. Then it is a time bound property. It will not be a lifetime or it will not be for eternal. It is a time bound property. Then territorial, that is it based on the different regions or different territories. So these are the uh, features of intellectual property. Now it is actually a broad topic. Intellectual property is so broad that it has many aspects. It stands for groupings of rights which individually constitute distinct rights. That means grouping of rights and individually also constitute different rights. However, its conception differs from time to time. That means it is not fixed and it has changed over the time and it is subject to influences and it depends on the perception also. The change in information technology, market reality globe due to deglobalization and how these things have affected the contents of intellectual property. For instance, olden days, because of religion, creation of life, plants or animals were not protected. And now we see there is a huge march on for protecting plants, animals. So similarly, defining this intellectual property is a bit difficult as its conception changes or as the perception changes. It is diverse, it is challenging, and has application in own day-to-day life. And we try to define this intellectual property and then intellectual property rights. So intellectual property is any creations of human mind. In simple words, you can define it as any creations of human mind. So we have seen that some product is designed by some human, by some person. That is nothing but the creation of human mind. Then, like tangible property, their creation has a value, and as with all the property, it needs to be protected. And this created thing is like a property or tangible property for that person, and it is need to be protected. And based on this property, we define intellectual property rights. It gives them this protection. These rights will give them or the person who has created the protection, as well as help them to exploit and control their intellectual property. It protects that intellect as well as help the person to exploit and control their intellectual property. The exclusive right granted by state to prevent others from using, manufacturing, distributing inventions, processes, applications, new and original designs, trademarks, new plant varieties, databases, artistics, and literary works. And such a person is known as rights owner or rights holder. The person who has done these points, so such person we call it as rights owner or rights holder. Now it has become an issue of wide and serious discussions because someone has created and other person has just copy pasted and he is not giving credit to that original person. So that's why this statement issue of wide and serious discussions with the formation of general agreement on trade related aspects of IPR under a Uruguay round the agreement of the GATT, now the World Trade Organization. So this has become an issue and this is worldwide. Talking about our nation, India is in priority watch list of USA under special 301 system, and it insists on some amount of novelty or originality. This is very important. IPR is given to the ideas who has novelty or originality to gain the protection. Intellect protect system is duration specific. Already I told that this is not lifetime or eternal. It is duration specific. We'll see what are the durations for different points. It does not provide perpetual and absolute monopoly over the property. So there is no monopoly, perpetual or absolute monopoly over the property. So other person can create other product for the same application. What is protected with respect to intellectual property is the use or value of ideas. Use or value of ideas or expressed ideas. If one's idea is there, the other person cannot use that same idea. That is nothing but the protection of the IP. However, bundle of rights constituting intellectual property is not over abstract ideas but rather over physical or concrete or tangible manifestations of these ideas. For example, rights under patent law include the right to manufacture. So, right to manufacture or distribute, while rights are under copyright law extend to the right of distribution, publication, etc., all of which deal with concrete embodiments of ideas and not the abstract ideas themselves. It means these ideas are not just abstract ideas. It should be related to physical or related to some theoretical or some specific point. And then these rights under patent law, one can uh, has right to manufacture or distribute. And intellectual property shall include the rights relating to, see what are these things, literary or artistic or scientific works. That means the authors, the publish researchers, so their literature work. Then artists, they can artistic work can be uh, included in this IPR. Then scientific works, some experiments or some uh, analysis is carried out. Then performance of performing artists, phonograms and broadcast, invention in all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks, and names, designations. These all are comes under IP. Then protection against unfair competition and all other rights resulting from intellectual activity in industry, scientific or literary or artistic ways. So this is based on the World Intellectual Property Organization Convention. So international trades like intellectual property, when they established or what are the timeline? Paris Convention for the Protection of Industrial Properties happened in 1883. Then Berne Convention for Protection of Literary and Artistic Works was in 1886. Then in International Union of New Varieties of Plants was done in 1961, subsequently in 72, 78 and 91. Then Convention on Biodiversity in 1992, Agreement on Trade Related Aspects of Intellectual Property Rights in 94, and Internet Treaties in 96. Now, what are the basic principle in IP? This is the contract between creator and sovereign state. That is production for elevation. So it is contract between the person who has created and the sovereign, the one who is going to use. It should balance between rights of creator and public interest. So there should be a balance between these creator and the public interest, rights and limitations and exceptions, whatever what the rights are with that particular copyright, and then what are the limitations while using it or what are the exceptions for using it. Now, in this regard, the constitutional aspects of IP are very important, and here we see that it helps courts and legislature arrive at and justify a balance between conflicting rights. So, constitute plays the important role in helping the court as well as the legislature, which arrives at and justify the balance between the conflicting rights. So there may be cases of confliction. So in such cases, constitution plays the important role. The US Constitution specifically protects the intellectual property, that is Article 1(8), by specifically providing to promote the progress of science and arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So, to promote the progress of science and arts, and at the same time securing for limited time to authors and inventors. So, it will secure that uh, science and arts invention for the limited time to their respect, whatever they have written or discoveries they have done. So, this is the US Constitution. Then Though there is no such intellectual property clause in the Indian Constitution, there are no constitutional restrictions on the power to make laws on intellectual property. So, as such, there is no clause in Indian Constitution, but there are no restrictions also to make the law. Now, the Constitution 44th Amendment Act 1978 struck off the right to property from the fundamental rights. However, property was made a legal right and was put under Article 300A in the right to property, which says no person shall be deprived of his property save by authority of law. So this is the amendment done in 1978. Then related to the intellectual property rights, some laws in India and those timelines are given here. First one is the Copyright Act was sanctioned in 1957 and this is done by the Higher Education Ministry or department. Then the Patent Act in 1970. This is done by the Industrial Policy and Promotions. Then Design Act in 2000, Trademarks Act in 1999, Geographical Indications of Goods, that is Registration and Protection Act. It is also done in the same year, 1999. The Semiconductor Integrated Circuits Layouts Designs Act in 2000. This is done under Information Technology Department. Then the protection of plant varieties and farmers' rights. So this is done under Agriculture and Cooperation Act. And these things one can see in the uh, government website, that is official website of IPR. You can see here. So you can see here related to patent, designs, trademarks, geographical integration, and other things. We can see about the history of Indian patents. So the Act 6 of 1856 on protection of invention based on the British Patent Law of 1952 is done. Then subsequently it is modified or some amendments have been done. And you can read here in 1972 the Act of 1859 was consolidated to provide the protection relating to designs. And every information is mentioned here. Similarly, one can apply for patents here. Then related to designs, industrial designs, trademarks, geographical integrations, and all these things can be viewed here. You can go through that website. Now, this intellectual property is mainly categorized in two parts. One is industrial property, second is copyrights and related rights. So we'll see this in detail, but in summary, you can see here through the pictures. In the industrial property, industrial designs are there. For example, this design of the bottle, then patents, trademarks or service marks. Some logos are there or trademarks are used like this TM orange. Then trade secrets. So these all examples you have seen. Then geographical indications, some jewelry or maybe Kolhapur chappal. Layout designs of semiconductor ICs. So semiconductor ICs layout and designs, those can be protected under here. Then plant varieties, farmers' rights, then copyright and literature. So all these comes under intellectual properties. So we'll see one by one. So mainly these are copyrights and related rights, and then industrial property, patents and industry design, trademarks, in geographical indications, layout designs, trade secrets, protection. Now, what is first we see copyright and related rights. So, original literary, dramatic, musical, or artistic works. So, these comes under copyright and related rights. So for example, some literature you have done, or some articles you have written, those things, or you have created some drama, or music, or uh, some artistic works that that comes under this copyright and related rights. So here work is in terms of ideas expressed in material form, no copyright in ideas or facts. So cinematographic films, sound recordings, these all comes under this part. Then rights are two types. One is moral rights and another is economic rights. So in moral right, to protect the personality of the author, suppose you have written some article and you don't want it someone is using your article as his. So there is one right, that is moral right, and another is economic right, that is one can uh, get benefits from economical benefits from the use of that right. So that is economic right. So we'll see one by one. In moral rights, it is the right of authorship, right of integrity, then digital manipulation or no rights for the display. These things comes under right of integrity and inalienable rights. So moral rights is dependent on the moral of the person. So right of authorship. So he should get the authorship right. Then one cannot do the digital manipulations or one cannot display it. So right of integrity is with him and inalienable rights. Then in the second kind or second type, that is economic rights, it includes right of reproduction, that is in reproduction, making copies or an edition of that particular novel. If you have written some novel and you are making copies of it or you are making versions of it. So one other person cannot do that. Storage in the computer memory, so you cannot store it in the computer memory. Right of distribution or issuing the copies. So the third person or the user cannot distribute it or issue the copies. Digital distributions also not possible. Right of communication to the public. So public performance, internet communication is also protected under economic rights. Then there is again second point is adoption rights. So conversion into another form, that is example literature to drama. Suppose you have written some novel and the second person is has read that literature and he is created some drama or film. So that is also protected under adoption rights. Abridgment, picturizations or comic formats. So if you cannot manipulate that original work. Right to make a cinematograph, film or sound recording. So as I said, you cannot uh, if you want to make it film or sound recording, then you need to take the rights from the original author. Translation rights also, rental rights, resale rights for original artistic works. So all these are comes under economic rights. So you should get the monetary benefits. Now ownership of rights generally related with the literary is related with the authors, the person who has written some article, novel, book. Then drama related with dramatist, then composer, the one who has created the music. Artistic work, that is artist or painter, sculptor, architect, photographers. Author of computer program, person who causes the work to be created, the person who has created that particular program, not the modified. Then producer, that is related with the cinematographic film. Then he is also responsible or owner of the sound recording. So these are the ownership of rights to individuals in the copyright and right copyrights work. Now, when we talk about author as owner or rights, now there are some exceptions. Now, what are those exceptions? Author as owner of rights. So, in the course of employment, for example, if you have written some article in some under some employer, then it cannot be your own article or it cannot be your own right to protect it. So this is the exception. Then employment by newspaper, magazines, employer has publishing right, other rights with the author. So if you are working with the employment and you have written some article in the newspaper, so that article it cannot be protected or you cannot be owner of alone owner of that particular article or magazine part. Photograph, painting, cinema for valuable consideration. Person who pays money. Suppose you pay money in a function to a photograph to take the photos. So those photos cannot be protected under owner's protection. Lecture delivered in public or person delivering. So if you are delivered some lecture in public or in the some workshops, then that cannot be protected. Government work is you cannot uh, claim the government work as if it is worse than public undertaking work. Similarly, work of international organization. So these are all the exceptions where you author as owner of rights cannot be protected. Then similarly, work of apprentice to teacher. Suppose you work as apprentice, then for a teacher, then that cannot be claimed as a owner or protected. If teacher writes a book, then teacher because he is employed to teach and not to write. So again, this is exception. Question paper or paper setter. If you set the some question papers, so that question paper cannot be protected, or you are not the author of that particular question paper. Encyclopedia or dictionary where you can edit, so those things cannot be your own. Music under contract by film producers. So if you have done some contract to a producer to create some music, then that cannot be claimed as your own or that cannot be copy protected. Then how to copyright or how to secure these copyrights? So one is formality free protection and voluntary registration. So registration does not as a matter of law establish what is registered is in fact and law copyrightable subject matter. So it is registration does not uh, make it as a law of matter. Now here comes the actual durations and all this. That is literature, dramatic, musical and artistic work published during lifetime of author and is copyrighted for the duration of that person's life or 60 years, whichever is early. Suppose one person has written some literacy or literary or music, then it is up to his life or it is up for 60 years. All other works 60 years from the date of publication, that is posthumous, anonymous works, works of government and public organizations, cinema and sound recording, photographs. These are all have copyright protection of up to 60 years from the date of publication. Now, the second part related rights. rights granted by law to communicators of works to the public. So again, here 2 points, mainly performance and broadcasting organizations. So under performance, recording, broadcasting and communicating to the public of a live performance. This is the right. Then presumption of transfer of performance rights to cinematography film producer, and generally this duration is 50 years from the publication. The second one is broadcasting organization. So one can broadcast reproduction rights, rebroadcast, recording and communicate to the public, and its copyright duration is 25 years. So you see that literary, dramatic, music, artistic works has lifespan of life plus 60 years or 60 years from the date of publication. And if it is related to the performance, then it is 50 years, and related to the broadcasting or rebroadcasting, it is up to 25 years. Now we'll see first point of the industrial design, that is patent. So actually this patent is designed by the Thomas Jefferson in 1790 to provide a brief legal monopoly to give the inventor an opportunity to get the invention into the market and recoup development costs before the competitors entered the market. So Thomas Jefferson wanted to uh, create an opportunity so that invention or inventors can get the development cost from that, and this is how the patent is started. It is a monopoly right granted by law for the exclusive use of an intellectual property to one or more individuals. The instrument by which such grant is made is known as patent. So we can say this is a monopoly right granted by law for exclusive use of an intellectual property to one or more individuals, and the instrument by which such grant is made is known as patent, and the patent to whom a patent is granted is called patentee. Now section 2M of the Indian Patents Act 1970 defines patent as: patent means a new product or process involving an inventive step and capable of industrial application. That is, a new product or process involving an inventive step and capable of industrial application. Such product or process we call it as patent. And it lays down like grant of revocation of patents, items not patentable, product patent, patent period, rights and obligations of patentee, working of the patent, compulsory licensing and exceptions. So these things we will see. After the expiry of the period for which exclusive right is granted to the inventor, 20 years generally in India, from the date of application, the invention can be put to use by any person other than the one to whom a patent has been granted. Now we can define it in other words. A patent is an exclusive right granted for an invention which is a product or a patent is an exclusive right granted for an invention which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem or industrial application. And the limited monopoly right granted by the state enables an inventor to prohibit another person from manufacturing, using, distributing, or selling the patented product, or from using the patented process without the permission of the patentee. And generally, it is the patent period is 20 years in India. So this is 20 years in India. In one of the case in 1979, that is in Bishwanath Prasad Radhesham versus Hindustan Metal Industries in 1979, the Supreme Court held that the object of patent law is to encourage scientific research, new technology, and industrial progress. So, grant of exclusive privilege to own, use, or sell the method or the product patented for a limited period stimulates new inventions of commercial utility. The price of the grant of monopoly is disclosure of the invention at the patent office, which after the expiry of the fixed period of the monopoly passes into the public domain. So this is the verdict made by the Supreme Court, Honorable Supreme Court in 1979. Now, what can be patented? So because any person says that I have created this or I have developed this process. So there are some clarity here. Inventions in all fields of technology, whether products or processes, if they meet the criteria of novelty, if they meet the criteria of novelty, then non-obviousness, that is inventive step, then industrial application, that is utility. So if the product or process meets the criteria of these 3 points, then it can be patented. We'll see one by one. Novelty. So what is novelty? Novelty means newness, something new you have created, either product or a process. So it is an invention depends upon the state of prior art, that is existing knowledge. You have used existing knowledge and similar invention already known in the particular field. And there will be no novelty if there has been prior publication and prior use of same or an identical invention. If you have identified or you have created some new process but you have published that work in a publication, or you have done some publication, then it cannot be uh, patented. Then in other words, invention must involve any innovation or technology which has not been anticipated by the publication in any document or used in the country elsewhere. So it should not been published priorly, or it should not have been documented anywhere in the country or elsewhere in the world before filing the patent application. Then such product or process can only be patented, applied for the patent, or or possible to get the grant. So it should be new and it should not have been published or documented anywhere in the country or over the world. The subject matter must not have fallen in the public domain. So that means it should not have fallen in the public domain. That is the main thing. Now, non-obviousness. That is, the invention must be non-obvious to a person skilled in the art to which the invention relates. Then the invention, besides being new and non-obvious, must also be useful. This is important. It should be useful. The invention cannot be put to any beneficial use of the mankind. It can be, if it is not useful for the mankind, then it cannot be patented. Then there are types of patent like utility patent. Whoever invents or discovers any new and useful process, machine manufactures, or composition of matter, or any new and useful improvement, therefore, may obtain a patent. So it should invents or discovers new and useful process, machine, manufacture, or composition of matter, or improvements, any new or useful improvement can obtain the patent. Now, it may be in terms of toys, coatings, tools, machines, good for 20 years. In a plant patent, whoever invents or discovers and sexually reproduces any distinct and new variety of plant. including cultivated spores, mutants, hybrids, and newly found seedlings other than tuber propagated plant or a plant found in an uncultivated state. So these can be also patented. Those are called as plant patent. Then the next one is design patent. Whoever invents any new, original, and ornamental design for an article of manufacture may obtain the patent. Like a decoration, apparel, jewelry. Then it can easily be designed around no functionality to protect under the Indian patent law. A patentable invention must be a new product or process. It should be non-obvious. It should be useful to the mankind and capable of industrial application. So it should be application useful for the industry. Already we have seen this condition for patentable novelty invention not known to public prior to claim by the inventor. Then inventive step not be obvious, so it should be invention not known to the public. Then non-obvious industry application. Just now we have seen it should be useful for the mankind and as well as to the industry. Then patents are granted by national patent offices after publication and substantial examinations of the applications. In India, provisions exist for pre-grant and post-grant opposition by others. So it may be possible that you get grant and if some opposition by others have done, then it may be you get post-grant. They are valid within the territorial limits of the country. So this is valid within the country, territorial limits of the country. Then foreigners can also apply for the patents in India. So this is one sample certificate of a patent issued by the United States. And here some patented actual document. Now, which parts are not patentable? Those things we will see in the next session. Thank you. So in this session, we have seen what is intellectual property, then what are the acts or the timeline of the laws in India related to intellectual property. Then mainly intellectual property is classified in two types, industrial property and copyrights and related rights. So we have seen copyrights and related rights related with the literary, drama, artistic works. And then we have started with the industrial property of patents. So this these are the classification. And in the copyright and related rights, we have seen literary, dramatic, music works, artistic works, recordings. Then again, these are having two rights: moral right, economic right. In moral right, what are the points to the author? And in the economic rights, then ownership of rights, who will be the owner of which uh, copyright material, and what are the exceptions or which are considered as intellectual property and which are not. Then the duration for the copyright. Then we have started with patent. So what is patent? And the period of patent is 20 years. And and what can be patented we have seen till now. In the next lecture we will start with the invention but that cannot be patentable or which cannot be applied or which cannot get the patent. So in the next session, we'll see the next part. Thank you.